guys, it's Rebecca from the second group of Constitutional Law 1. Join me and my group mates, Fah Kria, Gesslee, Princess, Richard, Hearthom, and Neddie as we share to you all about the judicial and the executive departments of the Philippines.
Hi everyone, our group is tasked to report about the executive department of the Philippine government. Who is the chief and the members of the executive department as stated in the 1987 Philippine Constitution? The executive department comprises the largest part of the country's bureaucracy. The secretaries of these departments are referred to as the Cabinet of the Philippines. The executive department possesses the power of the sword because it executes or enforces the laws of the land. Executive power is conferred by the 1987 Constitution in Section 1, Article 7 to the President of the Philippines. Thus, he is called as the Chief Executive. The members of the executive branch of the government are the President, the Vice President, the Cabinet, the Office of the President. The qualification for President or Vice President as stated in Section 2, Article 7 are the following: natural born Filipino citizen, registered voter, able to read and write, at least 40 years of age on the day of the election, and resident of the Philippines for at least 10 years immediately preceding the day of election. What about the manner of assumption and term of office? The President and the Vice President are voted separately during election. They acquire title to their position by the direct vote of the people. The candidate obtaining the highest number of votes shall be proclaimed elected by the Congress. With regards to the term of office, the President has one term only starting and ending at noon of the 30th of June. It is clear in the Constitution that the term of office of the President is fixed at 6 years without any authority to hold over unless the Constitution itself provide unequivocally that he can continue to do so. The President shall not be eligible for any re-election, and no person who has succeeded the President and has served as such for more than 4 years shall be qualified for election to the same office at any time. On the other hand, the Vice President has 2 consecutive terms, which is also good for 6 years each term, starting and ending at noon of June 30. No Vice President shall serve for more than 2 consecutive terms. Voluntary renunciation of office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. The presidential privileges are the following. The President shall have an official residence at the Malacañang Palace as stated in Article 7, Section 6 of the Constitution. The palace is located at the north bank of the Pasig River along GP Laurel Street in the district of San Miguel, Manila. The President shall receive a salary that shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after the expiration of the term of the incumbent during which such increase was approved. The President shall be immune from suit during his tenure. He can exercise his duties and function of running the country's affairs free from any hindrance or distraction. The President also has the presidential communication privilege, or what we call executive privilege, that covers all confidential or classified information between the President and the public officers. This kind of privilege enables the President to withhold certain information from disclosure to the public or even Congress. This is based upon constitutional principle of separation of powers, and it is designed to enable the President to receive candid advice from advisors, as well as to safeguard information, the disclosure of which might threaten national security. Prohibition, inhibition, disqualification. The President, the Vice President, members of the Cabinet, and their deputies and assistants shall not receive any other emolument, salary, or fee from the government or any other source, shall not hold any other office or employment during their tenure. Exception to this is the appointment of the Vice President as a cabinet member and the Secretary of Justice as ex officio member of the Judicial and Bar Council. Shall not practice directly or indirectly any other profession during their tenure. Shall not participate in any business. Shall not financially interested in any contract with or in any franchise or special privilege granted by the government, including government-owned and controlled corporation. Shall avoid conflict of interest in conduct of office. Shall avoid nepotism. Rules on succession, filling up of vacancies. Vacancy before the commencement of the presidential term. If the President-elect fails to qualify, the Vice President shall act as President until the President-elect shall have qualified. If the President shall not have been chosen, the Vice President shall act as President until a President shall have been chosen and qualified. If at the beginning of the term of the President-elect shall have died or have become permanently disabled, the Vice President-elect shall become President, where no President and Vice President shall have been chosen or shall have qualified, or where both shall have died or become permanently disabled. The President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall act as a President until a President or a Vice President shall have been chosen and qualified. The Congress shall provide for the manner in which one who is to act as President shall be selected until a President or a Vice President shall have qualified, in case of death, permanent disability, or inability of the officials that will be mentioned later.
True.
Vacancy during the term of office of the President. In case of death, permanent disability, removal from office, or resignation of the President, the Vice President shall become the President to serve the unexpired term. In case of death, permanent disability, removal from office, or resignation of both the President and Vice President, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall then act as President until the President or Vice President shall have been elected and qualified. The Congress shall, by law, provide who shall serve as President in case of death, permanent disability, or resignation of the acting President. He shall serve until the President or the Vice President shall have been elected and qualified, and be subject to the same restrictions of powers and qualification as the acting President. The Congress at 10 o'clock in the morning of the third day after the vacancy in the offices of the President and Vice President occurs, shall convene in accordance with its rules without need of a call, and within 7 days enact a law calling for a special election to elect a president and a vice president to be held not earlier than 45 days, not later than 60 days from the time of such call. Vacancy in the office of the vice president. Whenever there is a vacancy in the office of the vice president during the time for which he was elected, the president shall nominate a vice president from among the members of the Senate and the House of Representatives, who shall assume office upon confirmation of a majority vote of all the members of both houses of the Congress voting separately. The President's state of health voluntary declaration of inability. Whenever the President transmits to the President of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmit to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Whenever a majority of all the members of the Cabinet transmit to the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President of the Senate and to the Speaker of the House of Representatives his written declaration that no inability exists, he shall reassume the powers and the duties of his office. Meanwhile, should a majority of all the members of the Cabinet transmit within 5 days to the President of the Senate and to the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers and duties of his office, the Congress shall decide the issue. For that purpose, the Congress shall convene if it is not in session within 48 hours in accordance with its rules and without need of call. If the Congress within 10 days after receipt of the last written declaration, or if not in session within 12 days after it is required to assemble, determines by a 2/3 vote of both houses voting separately that the President is unable to discharge the powers and duties of his office, the Vice President shall act as the President. Otherwise, the President shall continue exercising the powers and duties of his office. That covers my report about the President as the Chief Executive. Thank you.
Good evening, classmates. Good evening, attorney. I will discuss to you the powers of the President. You can see this under the 1987 Philippine Constitution, Article 7, Executive Department. So what are the powers of the President? So the powers of the President are the following. We have the executive and administrative powers in general. We have the power of appointment and removal. We have the power of control and supervision. We also have military power, pardoning power or executive clemency, diplomatic power, delegated powers, powers to contract loan or the borrowing power. We have the residual power, and we have the other powers. I will discuss to you the first three presidential powers, while the remaining powers will be discussed to you by the other group members. So let's proceed with the executive and administrative powers in general. As the chief executive, the president is mandated to execute the laws of the land. Under Article 7, of the 1987 Philippine Constitution, Section 1, it states that the executive power shall be vested in the President of the Philippines. Before they enter on the execution of their office, the President, the Vice President, or the acting President shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully and conscientiously fulfill my duties as President or Vice President or acting President of the Philippines, preserve and defend its Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. So help me God. In case of affirmation, the last sentence will be omitted. So this oath is stated under Article 7, Executive Department, Section 5 of the 1987 Philippine Constitution. So what is the purpose of this Section 5, Article 7 of the 1987 Philippine Constitution? So the purpose of this is to instill in their minds and to declare to all that the said public officials have a solemn oath that they will faithfully and conscientiously fulfill their duties, that they preserve and defend the Constitution of the Philippines, that they will execute the laws of the Philippines, that they will do justice to every man, that they consecrate to themselves to the service of the nation, and that besides the solemn oath they take, they formally invoke and ask the help of God in the course of and in the fulfillment of their duties. So the President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed as stated under Section 17, Article 7 of the 1987 Philippine Constitution. We have this so-called faithful execution clause. Until and unless a law is declared as unconstitutional, the President has a duty to execute it regardless of his doubts as to its validity. So accordingly, it was held that the execution of laws as embodied in the oath of the President is more of an obligation than a conferment of power. Thus, there is but one choice for the President to take if he believes that a law is not constitutional or void. That is to challenge the law in an appropriate judicial action and only after the Supreme Court has made a final declaration on what the law is. The President is mandated to obey such declaration and implement the law if declared constitutional and abandon it if declared as not constitutional. So as an exception to the faithful execution clause, we have this doctrine of executive impoundment. So impoundment refers to a refusal by the President for whatever reason to spend funds made available by Congress. It is the failure to spend or obligate budget authority of any type. The proponents of this theory insist that the faithful execution of the laws requires that the President desist from implementing the law if doing so would prejudice public interest. An example given is when through efficient and prudent management of a project, substantial savings are made. So in such a case, it is sheer folly to expect the President to spend the entire amount budgeted in the law. So in appointment, it is the act of the appointing power. It may include the issuance by the President of the Commission, which is the written evidence of the appointment. And acceptance, it is the act of the appointee. He may or may not accept the appointment, but acceptance thereof is necessary to enable him to have full possession, enjoyment, and responsibility of an office. It is not, however, necessary to the legality of the appointment. So, to the kinds of acceptance, acceptance may be implied or expressed. It is expressed when done verbally or in writing, and it is implied when without formal acceptance, the appointee enters upon the exercise of the duties and functions of an office. The best formal evidence of the acceptance is undoubtedly the qualifications of the officer appointed by taking the oath of office. So let's proceed to the limitations on the presidential powers to appoint. The first limitation is that the president may not appoint his spouse and relatives by consanguinity or affinity within the fourth civil degree during his term as members of the Constitutional Commission's Office of the Ombudsman or as secretaries, undersecretaries, chairmen or heads of bureaus or offices, including government-owned or controlled or government-controlled corporations and their subsidiaries. Second, the president or acting president cannot exercise the power to appoint 2 months before the next presidential elections and up to the end of his term, except temporary appointments to executive positions when continued vacancies therein will prejudice public service or endanger public safety. Third, the other mentioned in the first group under Section 16, Article 7 are subject to the confirmation of the Commission of Appointments. Those are the heads, consuls, as mentioned earlier a while ago. And then appointments in the judiciary shall made upon recommendation of the Judicial and Bar Council. Fifth, appointments extended by the acting president shall remain effective unless revoked by the elected president within 90 days from his assumption or reassumption of office. And then the last two limitations are the following. The president shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effective only until disapproval by the Commission on Appointments or until the next adjournment of the Congress. And Congress may prescribe the qualifications required of a public office. So we also have a distinction between permanent appointment and temporary appointment. So a permanent appointment is extended to persons who possess the required eligibility. As such, they enjoy security of tenure. Whereas temporary appointment, it is revocable at will and without the necessity of just cause or a valid investigation. As the term itself connotes, the temporary appointee may be replaced at any time a permanent choice is made. We also have a distinction between regular appointment and the ad interim appointment. So in regular appointment, it is an appointment made by the president while Congress is in session. It takes effect only after the confirmation by the Commission on Appointments. While the ad interim, it is an appointment made by the president while Congress is not in session. It takes effect immediately but ceases to be valid if disapproved by the Commission on Appointments or upon the next adjournment of Congress. We also have ad interim versus the appointment in an acting capacity. The ad interim, it is an appointment that refers only to positions which need confirmation by the CA or the Commission on Appointment. The appointment may be given only when Congress is not in session. So while the appointment in an acting capacity, the said appointment is given to those which do not need confirmation, and the appointment may be given even when Congress is in session. So we have steps in the appointing process. We have the appointment and the acceptance. The acceptance have two kinds. We have two kinds of acceptance, which are the express and implied acceptance. So let's proceed with the second presidential power, which is the power of appointment and removal. So we have the power of appointment. Power of appointment is the selection by the authority vested with the power of an individual who is to exercise the functions of a given office. So under Section 15, Article 7 of the 1987 Philippine Constitution, we have the kinds of presidential appointments. We have the appointment made by an acting president. We have midnight appointment. We have the regular presidential appointment, and we have the ad interim appointment. So midnight appointment is defined as an appointment to political office made during the last hours of the term of office of the person in whom the right of making such appointment is vested, which is it is vested under the president. So we appointments requiring the consent of the Commission of Appointments. It is stated under Section 16, Article 7 of the 1987 Philippine Constitution. We have the heads of executive departments except the Vice President. We also have the ambassadors and other public ministers and consuls, officers of the Armed Forces of the Philippines from the rank of colonel or naval captain, officers whose appointments are vested in him by the Constitution. We also have the appointments without the need of the Commission of Appointments confirmation. We have those vested by the Constitution on the President alone. We have appointments that are not otherwise provided by law. We have those authorized by law to appoint, and those officers lower in rank whose appointment is vested by law in the President alone. So distinctions. Appointment versus designation. We have appointment. In appointment, the person who shall exercise the function of a given office is selected by the authority vested with the power to make a selection. In designation, it is a person who is already in the public service is given additional duties. These duties are usually imposed by law. So, power of removal. The power of removal is implied from the power to appoint. That is the general rule. So, the exception to that general rule is that those appointed by him or those who are appointed by the president, where the Constitution prescribes certain methods for separation from public service, for example, the chairman and commissioners of constitutional commissions who can be removed, they can only be removed by impeachment, or judges who are subject to the disciplinary authority of the Supreme Court. So, while the power, while the president has the power to appoint, the president is powerless to remove them because the Constitution provides that these officers can only be removed by impeachment. Also, while judges of lower courts are appointed by the president upon the recommendation of the Judicial and Bar Council, yet the president is likewise stripped of the power to discipline or remove them because the Constitution exclusively vests upon the Supreme Court the power to discipline or dismiss judges of lower courts. However, those who hold office at the pleasure of the president can, with or without cause, be removed anytime at the discretion of the president. So let's proceed to the next power, which is the power of control and supervision. So the power of control. The power of control is the power of a superior officer to alter, modify, nullify, or set aside what a subordinate official had done in the performance of his duties and to substitute the judgment of the former to the latter. So it implies the right of the superior officer to interfere in the exercise of such discretion as may be vested by law in the subordinate officer. While supervision is the overseeing or the power or authority of an officer to see that subordinate officers perform their duties. If the subordinates fail or neglect to fulfill them, then the officer may take such action or steps as prescribed by law to make them perform these duties. Power of control. Under the power of control, we have the doctrine of qualified political agency or the alter ego principle. All the different executive and administrative organizations are mere adjuncts of the executive departments. The members of the cabinet of the president are referred to as his alter egos, for even if they are the heads of the different departments of the government, they are considered as the extension of the personality of the president. For this reason, acts performed and promulgated in the regular acts of business are unless disapproved or reprobated by the chief executive, presumptively the acts of the chief executive. So let me end the part of my lecture with a quote by Aiduo Koyenikan that the mind is just like a muscle. The more you exercise it, the stronger it gets and the more it can expand. Thank you.
Hi, I am Hearthom Herald or Tampac, and today we will be tackling some of the powers vested to the executive department, particularly the military, pardoning, and diplomatic powers. First, let's talk about military power. According to Section 18 of the Article 7 of the 1987 Constitution, the President shall be the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. The role of the President as a Commander-in-Chief are the following. First, the President acts as a Commander-in-Chief. Second, he or she calls out the Armed Forces of the Philippines, or AFP, to prevent or suppress lawless violence. Third, the President has the authority to prevent any members of the AFP from testifying in legislative inquiries unless ordered by a judicial order. And fourth, the President can suspend the writ of habeas corpus for 60 days when public safety requires it. And lastly, fifth, the President can place the whole or part of the Philippines under martial law. We can remember these roles by remembering this acronym, ACT-SM. Now, what is the writ of habeas corpus? Edgardo M. Villarreal defined it as a writ directed to a person detaining another, commanding him or her to produce the body of the prisoner at a designated time and place, with the day and cause of his or her capture and detention, to submit to, and receive whatever the court or judge awarding the writ shall consider in his behalf. Martial law, on the other hand, refers to that law which has application when the military arm does not supersede civilian authority, but is called upon to aid it in the execution of its civil function. It includes the following laws. First, military law power. Second, the principles governing the conduct of military forces in times of war and in the government of occupied territory. And third, the laws which has application when the military arm does not supersede civil authority but is called upon to aid in the execution of civil functions.
Now, what are the limitations on the exercise of military powers?
First, the President can call for the armed forces when it is necessary to prevent or suppress lawless violence. Second, suspension of writ of habeas corpus happens only when there is rebellion or invasion and when the public safety requires it. Third, Martial law shall not exceed 60 days, and within 48 hours of proclamation, Congress should convene in order to support or revoke the action. Fifth, if the Congress revoke the President's action, the President cannot set aside the said move from the Congress. Sixth, the Congress also, upon the initiation of the President, can extend the proclamation of martial law. Seventh, the Supreme Court can review the actions of the Congress and of the President. 8. Declaring martial law does not automatically suspend the privilege of the writ of habeas corpus, and the said suspension shall apply only to persons facing charges of rebellion or offenses connected to invasion. And lastly, any person arrested for the said offenses must be judicially charged within 3 days, or he shall be released. The other two branches of the government can check the action of the President, especially when declaring martial law or suspension of the writ of habeas corpus. First, let's talk about the legislative check. The Congress shall convene in accordance with its rules without any need of a call within 24 hours following the proclamation of martial or suspension by the President. The Congress may revoke such proclamation or suspension by a vote of at least a majority of all its members in the session. In the same manner, the Congress may extend, upon the initiative of the President, the proclamation or suspension for a period determined by the Congress. Now, in the judicial check, an appropriate proceeding filed by any citizen, the Supreme Court may review the sufficiency of the factual basis of the proclamation or the extension thereof, and must promulgate its decision within 30 days from its filing. The Section 19 of the Article 7 states that, except in cases of impeachment or as otherwise provided in this Constitution, the President may grant reprieves, commutations, and pardons, and remit fines and forfeitures after conviction by final judgment. He shall also have the power to grant amnesty with the concurrence of a majority of all the members of the Congress. The President has the power to grant the following: Number 1, pardon. Number 2, amnesty, which is subject to the concurrence of the majority of the members of the Congress. And number 3, reprieve. And lastly, parole. Now let's talk about pardon. Pardon is an act of grace which exempts the individual on whom it is bestowed from the punishment which the law inflicts for the crime he has committed. It is a private and official act of the President. There are two classes of pardon. It is absolute, when the President does not impose any conditions or qualifications upon the pardonee. It is complete even without the necessity of acceptance. Conditional, on the other hand, is when the President annexes or attaches certain terms or qualifications as he deems fit. It requires the acceptance by the pardonee for its validity. The pardoning power of the President has a limitation, just like his or her other powers. First, the President can exercise the power only when the pardonee receives his conviction by final judgment. Second, the President cannot extend to cases of impeachment. Third, the President cannot extend on matters involving election laws. Fourth, pardon cannot extinguish civil liability. Fifth, pardon does not restore offices forfeited or vacated. Sixth, determination as to whether there is a violation of conditions rests to the President. And lastly, pardon cannot be exercised on judicial and legislative contempt. The doctrine of non-diminution or non-impairment of the President's power of pardon by acts of Congress considers that any act of Congress by way of statute cannot operate or delimit the pardoning power of the President. Amnesty is an act of sovereign power granting oblivion or a general pardon for a past offense, and is rarely, if ever, exercised in favor of a single individual, but is usually addressed to certain classes of persons who are subject to trial but have not yet been convicted. What is the difference between pardon and amnesty? Pardon is granted by the chief executive while amnesty requires the concurrence of the Congress. Pardon is granted to one after final judgment of an offense. Amnesty is granted to those who may be guilty of political offense. Pardon looks forward and relieves the offender of the consequences of the offenses. It abolishes and forgives the punishment, not the offense. In the amnesty, on the other hand, it looks backward by abolishing the offense itself as though he had committed no offense. Reprieve. Reprieve is the withdrawal or withholding of punishment for a time after conviction and sentence. It is in the nature of a stay of execution. It postpones the execution of a sentence to a day certain. It does not and cannot defeat the ultimate execution of the judgment of the court, while commutation, on the other hand, is the reduction of penalty from a greater punishment to a lighter one even without need of acceptance of the convict. Lastly, parole. Parole is not pardon. Rather, the prisoner remains in the legal custody. Parole is not a vacation of sentence imposed or a commutation of punishment. It suspends the execution of penalty and temporarily releases the convict from imprisonment on conditions which he or she is at liberty to reject. Although the prisoner is conditionally released, the sentence is not set aside, nor the offense obliterated. He is still under the supervision of the parole board and subject to be remanded to prison if grantee fails to perform and violates the conditions of the parole. Sections 1, 16, 20, and 21 of the Article 7 of the 1987 Constitution said, and I quote, Section 1, the executive power shall be vested in the President of the Philippines. The President shall nominate and with the consent of the Commission on Appointments, appoint ambassadors, other public ministers, and consuls. The President may contract or guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Monetary Board and subject to such limitation as may be provided by law. The Monetary Board, within 30 days from the end of every quarter of the calendar year, submit to the Congress a complete report of its decision on application for loans to be contracted or guaranteed by the government or government-owned and controlled corporations, which would have the effect of increasing the foreign debt and containing other matters as may be provided by law. Section 21. No treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. The conduct of the foreign relations or diplomatic power is vested in the head of state or sovereign. In the case of the Philippines, the President holds actual executive power including the conduct of foreign relations. The diplomatic powers of the President are: number 1, he or she is the head of the state and the repository of executive power. The President may enter into a treaty or executive agreement, but 2/3 of the members of the Senate shall concur with his or her decision. The President shall nominate and with the consent of the Commission of Appointments, appoint ambassadors, other public ministers, and consuls. Number 4, the President may contract or guarantee foreign loans. We can remember these 4 powers by these mnemonics: hostile.
Treaty and Executive Agreement. Treaty is a formal document which requires the Senate to ratify it. Executive agreement becomes binding without the concurrence from the Senate. International agreements involving political issues or changes of national policy takes the form of treatises. international agreements where it embodies adjustments of details in carrying out national policies and traditions, and only takes a temporary time, usually takes form of executive agreement.
The President is the chief architect of the Philippines' foreign relations. He negotiates and ratifies treaties, and not even the Senate or the House of Representatives, unless as may intrude on that process. The President is the sole organ of the nation in its external relations and its sole representative with foreign nations. In PMPF versus Manglapus, the court held, and quote, "The President alone has the power to speak or listen as a representative of the nation. He or she makes treaties with the advice and consent of the Senate, but he or she alone negotiates. Congress is powerless to invade it. The power to ratify is vested in the President, subject to the concurrence of the Senate. However, the role of the Senate is limited only to giving or withholding its consent or concurrence. The President also has the authority to refuse to submit a treaty to the Senate. Further, the court cannot enroach a writ of mandamus against the action of the President." So there you have it, guys. Those are the powers of the executive department when it comes to the military power, pardoning power, and diplomatic power. Again, I am Herald Tampac. Thanks for watching. See you in the next video.
Hello once again. I hope everyone's doing well. So today we will continue discussing the other powers of the President in addition to those discussed by Gesslee and Hearthom. Our discussion will focus mainly on the remaining powers of the President, namely the delegated power, second, the power to contract loans or also known as the borrowing power, third, the residual power, and fourth, the other powers of the President. Article 6 of the 1987 Constitution provides for the delegated powers of the President. This includes number 1, the exercise of the emergency power, and number 2, the tariff powers. So now we will thoroughly discuss what is the exercise of the emergency power of the President. Article 6, Section 23, Paragraph 2 of the 1987 Constitution states that in times of war or other national emergencies, the Congress may, by law, authorize the President for a limited period and subject to such restrictions as it may prescribe to exercise power necessary and proper to carry out a declared national policy. Unless sooner withdrawn by resolution of the Congress, such power shall cease upon the adjournment thereof. Before the Congress grants the President the emergency power, the following conditions shall be met. First, there must be war or national emergency. Second, the delegation must be for a limited period only. Third, the delegation must be subject to such restrictions as the Congress may prescribe. And lastly, the emergency powers must be exercised to carry out a national policy declared by the Congress. There is difference with regards to the emergency powers delegated to the President versus the President's military power. When the President acts under the Commander-in-Chief Clause, he acts under a constitutional grant of military power, which may include the lawmaking power. But when the President acts under the emergency power, he acts under a congressional delegation of lawmaking power. There is also a distinction between the President's authority to declare a state of national emergency and the exercise of his emergency power. The declaration by the President of a national emergency requires no congressional enactment. The President could validly declare the existence of a national emergency and no legitimate constitutional objection can be raised. Whereas, before the President could exercise his emergency power, such should be delegated first by the Congress. Let's now proceed to the second delegated power of the President, which is the tariff power. Article 6, Section 28, specifically the paragraph 2 of the 1987 Constitution, discusses the tariff power of the President. It states that the Congress may authorize by law the President to fix within specified limits and subject to such limitations and restrictions as it may impose tariff rates, import and export quotas, tonnage and wharfage dues, and other duties or imposed within the framework of the National Development Program of the government. Next is the President's power to contract loan, or also known as the borrowing power. The President may contract or guarantee foreign loans on behalf of the Republic of the Philippines, with the prior concurrence of the Monetary Board and subject to limitations as may be provided by law. So as example, during this time of pandemic, we all know that it is the President who had contracted loans to other financial institutions or other countries so as to sustain the expenses incurred during the pandemic. Next is the residual powers of the President. Residual powers are unstated powers possessed by the President, which are not enumerated in the Constitution, implied with the grant of executive power, and is not possessed by the Legislative and Judiciary Department. It includes power unrelated to the execution of any provisions of law. It should be noted that the executive power is more than the sum of specific powers enumerated in the Constitution. Whatever power inherent in the government that is neither legislative nor judicial has to be executive. Next, the power involved is the President's residual power to protect the general welfare of the people. It should also be noted that as steward of the people, it is not only the power of the President but also his duty to do anything not forbidden by the Constitution or the laws that the needs of the nation demands. Lastly, it is the power borne by the President's duty to preserve and defend the Constitution. The other powers vested on the President are the following. First, to call the Congress to special session. Second, to approve or veto bills. As a general rule, all bills must be approved first by the President before they become law. The power of the President to reject or veto bills has also its exceptions. So the exception on the power of the President to approve or veto bills are the following. First, the veto of the President is overridden by 2/3 vote of all the members of the Congress. President returns bill with his veto message to House where the bill originated, which shall then enter the objections at large in its journal and proceed to reconsider it. If, after such reconsideration, 2/3 of all the members of such House shall agree to pass the bill, it shall be sent together with the objections to the other House by which it shall likewise be considered. And if approved by 2/3 of all the members of that House, it shall become a law. Second exception, the bill lapses into law because of the President's failure to act on the bill within 30 days. And lastly, the bill passed is the special law to elect the President and Vice President. Next power of the President is the informing power. The President shall address the Congress at the opening of its regular session. He may also appear before it at any other time. Other powers of the President are the budgetary power and lastly, the power of augmentation. Article 6, Section 25 of the 1987 Constitution provides that no law shall be passed authorizing any transfer of appropriations. However, the President may, by law, be authorized to augment any item in the General Appropriations Law for their respective offices from savings in other items of their respective appropriations. So now we have discussed already the different important matters concerning the executive department. Let us now proceed to another topic, the branch of the government which was not discussed yet, the Judicial Department. The Judicial Department is composed of the Supreme Court and all lower courts. Judicial Department is said to be the most passive department as it neither possesses the power of the purse nor the power of the sword. It is said to be the most passive department since the judiciary can only adjudicate on justiciable and bona fide controversy brought before it. The judiciary is vested within the power to annul the acts of neither the legislative or executive department or both when not in conformance of law. In order to maintain the independence of the judiciary, the following safeguards have been embodied in the Constitution. Number 1, the Supreme Court is a constitutional body. It cannot be abolished, nor may its membership or the manner of its meeting be changed by mere legislation. Second, the members of the Supreme Court may not be removed except by impeachment. Third, the Supreme Court may not be deprived of its minimum, original, and appellate jurisdiction as prescribed in Article 8, Section 5 of the Constitution. Fourth, the appellate jurisdiction by law without its advice and concurrence. Fifth, appointees to the judiciary are now nominated by the Judicial and the Bar Council and no longer subject to confirmation by Commission on Appointments. 6. The Supreme Court now has administrative supervision over all lower courts and their personnel. 7. The Supreme Court has exclusive power to discipline judges of lower courts. 8. The members of the Supreme Court and all lower courts have security of tenure, which cannot be undermined by a law reorganizing the judiciary. 9. They shall not be designated to any agency performing quasi-judicial or administrative functions. 10. The salaries of judges may not be reduced during their continuance in office. 11. The judiciary shall enjoy fiscal autonomy. So in order to understand more, we will first find the meaning what is fiscal autonomy. Fiscal autonomy means freedom from outside control. As envisioned in the Constitution, fiscal autonomy enjoyed by the judiciary contemplates a guarantee of full flexibility to allocate and utilize their resources with the wisdom and dispatch that their needs require. The reason for this fiscal autonomy is that it is granted to the Supreme Court to strengthen its autonomy. The provision is intended to remove courts from the mercy and caprice, not to say vindictiveness of the legislator when it considers the General Appropriation Bill. Another for judicial independence is number 12. Only the Supreme Court may order the temporary detail of the judges. And lastly, the Supreme Court can appoint all officials and employees of the judiciary. So now we have already discussed the remaining powers of the President or the Executive Department and the initial topics for the Judicial Department. The other topics concerning the Judicial Department will be discussed by my group mates. So I hope everyone will still listen and will give them their full attention. Thank you so much for listening.
Hi guys, I'm Rebecca and I'm here to discuss to you about judicial restraint, judicial power, and the constitutional basis for judicial review. Judicial restraint is a theory of judicial interpretation that encourages judges to limit the exercise of their power. It is a common law principle that serves the public interest by allowing the political process to operate without undue interference. The doctrine of separation of powers imposes upon the courts proper restraint born of the nature of their functions and of their respect for the other departments in striking down acts of the legislature as unconstitutional. The judiciary will not interfere with their co-equal branches when: first, if there is no showing of grave abuse of discretion on the part of a branch or instrumentality of the government, the court will decline exercising its power of judicial review. Second, if the issue is a political question. Even when all the requisites of justiciability have been met, judicial review will not be exercised when the issue involves a political question. Guidelines for determining whether or not a question is political. First, there is a textually demonstrable constitutional commitment of the issue to a political department. Second, lack of judicially discoverable and manageable standards for resolving it. Third, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. Fourth, impossibility of a court's undertaking independent resolution without expressing lack of the respect due to coordinate branches of government. Fifth, an unusual need for unquestioning adherence to a political decision already made. And sixth, potentiality of embarrassment from multifarious pronouncements by various departments of one question. Judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Pursuant to the doctrine of separation of powers, judicial power cannot be shared, as the powers of the legislature and the executive cannot also be shared. The essence of judicial review is derived from the constitutionally mandated judicial power. Judicial review is part of the elaborate system of checks and balances of a democratic form of government. It is the idea that the actions of the executive and legislative branches of the government are subject to a review and possible invalidation by the judiciary. It allows the Supreme Court to take an active role in ensuring that the other branches of government abide by the provisions of the Constitution. The following are the requisites for judicial review. First, the existence of actual case or controversy. Second, the issue must be raised by the proper party. Third, it must be raised at the earliest possible time. And fourth, must be necessary for the final determination of the case. The existence of an actual case or controversy is a condition precedent for the court's exercise of its power of adjudication. Actual case or controversy is an existing case or controversy which is both ripe for resolution and susceptible of judicial determination, and that which is not conjectural or anticipatory, or that which seeks to resolve hypothetical or feigned constitutional problems. For an actual controversy to exist, there must be a legally demandable or enforceable right which is violated by another, who in turn has the correlative duty to respect it. The second requisite, a proper party, is one who has sustained or is in immediate danger of sustaining an injury as a result of the act complained of. To have legal standing, therefore, a suitor must show that he has sustained or will sustain a direct injury as a result of the action, or have a material interest in the issue affected by the challenged act. The second requisite is sometimes referred to as the locus standi. Third requisite. The earliest opportunity to raise a constitutional issue is to raise it in the pleadings before a competent court that can resolve the same, such that, if not raised in the pleadings, it cannot be considered in trial, and, if not considered in trial, it cannot be considered on appeal. This is the general rule. There are exceptions. First, in criminal cases, it is at the discretion of the court. Second, in civil cases, if necessary for the determination of the case itself, and third, when the jurisdiction of the court is involved. The fourth and last requisite. The decision of the constitutional question must be determinative of the case itself. Its constitutionality must be the cause of the suit or action. The constitutionality of an act of the legislature will not be determined by the courts unless the question is properly raised and is necessary to the determination of the case. The issue of constitutionality must be the very lis mota presented. That's it for my topics. To learn more about the Judicial Department, stay tuned and listen to Fah Kria.
Hi, good day. I am Fah Kria Abdul of Group 2, Section Plato. So the topic that was assigned to me is judicial restraint up to requisites of judicial review. So again, good day. So in judicial restraint, uh, basically, it is a theory of judicial interpretation that encourages judges to limit the exercise of their own power. It is also a common law principle that serves the public interest by allowing political process to operate without undue interference. Thus, the doctrine of separation of powers applies. Separation of powers imposes upon the courts proper restraints of their functions and respect for other departments in striking down acts of the legislative or executive as unconstitutional. So that's judicial restraint. It talks about the limitations of exercise of judicial power. So what is judicial power? It is stated in Article 8 that judicial power is vested in the Supreme Court or is vested in one Supreme Court and in such lower court as may be established by law. They are also the authority to settle justiciable controversies or disputes including rights which are legally enforceable and demandable. They are also the authority to determine the abuse of discretion of lack or excess of jurisdiction to eliminate the defense of political question and striking down the abuse of government. So there are two kinds of judicial power. The traditional judicial power and the expanded judicial power. In traditional judicial power, the power is to settle actual controversies involving rights which are legally demandable and enforceable. In expanded judicial power, the power is determined whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. So before, judicial power only focuses on traditional judicial power, but it was expanded during the or after the regime of Marcos, because it was said that because of the limitation of judicial power, the other political powers are able to abuse or exceeds on their powers vested to them. So, in other words, traditionally, the courts cannot question the political acts of the other departments of the government. Courts then only settle justiciable questions or questions involving rights and laws, and it cannot and it not uh, questions involving and not political questions. They cannot questions political which address to wisdom or discretion of political departments. But with the expanded judicial power, um, the courts can now determine if the political departments gravely abuse the exercise of their discretion amounting to lack or excess of jurisdiction. So that's judicial power. In political question distinguished from the justiciable question. Political question is an issue which involves the policy or the wisdom of the law or act, or the morality or efficacy of the same. In other words, political question refers to those issues which, under the Constitution, are to be decided by the people in their sovereign capacity. Generally, courts cannot inquire political questions, but accordingly, while courts can determine questions of legality with respect to governmental action, they cannot review government policy and thereof, for these questions have been vested by the Constitution in the executive and judicial departments. In justiciable question is an issue that affects the civil, personal, or property rights according to every member of community or the nation. So this talks about the individual or private persons, as it's mentioned in the traditional judicial power. And the distinction of these three: the judicial power, judicial review, and judicial inquiry. So, judicial power is the power to apply the laws to contests or disputes between litigants in cases properly brought before the judicial tribunal, or concerning legally recognized rights and duties between states and private person. Judicial review is an aspect of judicial power. However, it connotes different meaning. In judicial review is the power of the court to interpret the Constitution and to declare any legislative or executive act invalid. In judicial inquiry, it is the power of the court to inquire into the exercise of discretionary powers, whether there is a grave abuse of discretion amounting to lack or excess of jurisdiction. So that's the difference of these three rather. So in Article 8, Section 5, it states the constitutional basis of judicial review. First, the appellate jurisdiction of the Supreme Court to review, revise, reverse, modify, or affirm on the appeal of certiorari as the law or the rules of courts may provide final judgment and order of lower courts. Second, number 2, all cases involving in constitutionality of treaty, international or executive agreement or law which shall be heard by the Supreme Court en banc. Though the Supreme Court en banc will be discussed to you by my co-reporter, Mr. Ordoñez, later on his video. So third, to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch of the government. So that is number 3. Let's continue. And function of judicial review or function of judicial review. There are 3 functions of it. First, legitimate of positive function. The function of sustaining the validity or the constitutionality of the law or the act. Second function is a negative or checking function. The act of pronouncing a law or act unconstitutional for transgressing the Constitution. So, in the judicial review, if the court finds out that a particular act or a particular laws are unconstitutional, it will not hesitate to or automatically they will declare that the acts or laws that has been promulgated by the legislative or in executive is void or invalid. So, in symbolic or teaching function, the act conveying to the members of the bench or in the bar the controlling doctrinal law or jurisprudence pronouncement of the Supreme Court to serve in deciding cases. In number 3, this is talks about the stare decisis or the jurisprudence of the previous decision of the Supreme Court that may be used on a particular issues provided that um, they are parallel in cases and in circumstances. So that's function of judicial review. So here the requisites, the last one, the requisites of judicial review. Though so in order to judicial review to prosper, it must conquer the four requisites of judicial review. So first, there must be existence of actual case or controversy. So when we say the existence of actual case or controversy, it is a condition precedent for the court's exercise of the power of adjudication. Actual case or controversy is an existing case or controversy which is both ripe, ripe um, for the resolution and susceptible of judicial determination. There must be a definite and concrete dispute touching on the legal relations of the parties who have adverse legal interest. The reason is that the issue ceases to be justiciable when a controversy becomes smooth and academic. When we say smooth and academic, it is where a resolution thereof can no longer have practical effect or in a nature of things cannot be enforced, or it is no longer ripe for judicial determination, and courts should decline jurisdiction over such cases or dismiss it on the ground of mootness. So, second requisites, the issue must be raised by the proper party. So, the proper party here is one who sustained or in immediate danger or sustaining an injury as a result of the act complained of. To have a legal standing or lucus standi, a suitor must show that he has sustained or will sustain direct injury as a result of the action or have material interest in the issue affected by the challenged act. So that's number 2 requisites. In number 3 requisite, there must be raised at the earliest possible time. So the earliest opportunity to raise constitutional issue is to raise it in the pleadings. Of course, in pleadings. Before a competent court that can resolve the same. Such that if not raised in the pleadings, it cannot be considered in trial. And if it's not considered in trial, it cannot be also considered in appeal. So that's number 3. And number 4, must be necessary for the final determination of the case. The fourth requisites of judicial review speaks about the issue of constitutionality must be the least mota of the case. So, in other words, the decision of the constitutionality questions must be determinative of the case itself. Its constitutionality must be the case of the suit or actions. So that's number 4 requisites. So I think that's all my report in judicial function reviews and judicial power. So thank you so much for watching.
Hello everyone, I am Richard Ordoñez and I will be explaining to you the appointments to the judiciary.
Let us first know the qualifications of members of the judiciary. For the justices of the Supreme Court and the collegiate courts, an individual to be qualified must be a natural-born Filipino citizen who is at least 40 years of age, worked for 15 years or more as a judge of a lower court, or has been engaged in the practice of law in the Philippines for the same period. They must hold office during good behavior until they reach the age of 70 or become incapacitated to discharge their duties. An individual must be proven with competence, integrity, probity, and independence. For the RTC judge, an individual must be a natural-born Filipino citizen who is at least 35 years of age and has been engaged for at least 10 years in the practice or has held public office in the Philippines, requiring admission to the practice of law. They must hold office during good behavior until they reach the age of 70 or become incapacitated to discharge their duties. An individual must be proven with competence, integrity, probity, and independence. For the MTC or MCTC judge, an individual who is a natural-born Filipino citizen, at least 35 years of age, and has been engaged for at least 5 years in the practice or has held public office in the Philippines, requiring admission to the practice of law. Hold office during good behavior until they reach the age of 70 or become incapacitated to discharge their duties. An individual must be proven with competence, integrity, probity, and independence. In the case of Cayetano versus Munsud in 1991, GR number 100113, practice of law was being defined not limited to litigation. Now let us talk about the removal from office.
To litigation, it means that any activity in and out of court
Impeachment on grounds provided for by the Constitution. For the lower courts, judges may be disciplined or removed by the Supreme Court sitting en banc by a vote of a majority of the members who took part in the deliberations on the issues in the case. This procedure cannot be abbreviated by filing criminal or administrative proceedings against them, based on the fundamental principles of judicial independence and separation of powers. It is the clerk of court of the Supreme Court who shall keep a record of its proceedings and not a member of the Judicial and Bar Council. In the absence of the Chief Justice because of his impeachment, the most senior justice of the Supreme Court, who is not an applicant for Chief Justice, should participate in the deliberations for the selection of nominees for the said vacant post and preside over the proceedings. It is pursuant to Section 12 of the Republic Act No. 296 or the Judiciary Act of 1948. Now let us talk about the appointment, tenure, salary of JBC members. Now let us talk about the appointment, tenure, and salary of the Judicial and Bar Council members. For ex officio members, the position in the council is good only while the person is the occupant of the office. Why is there only one representative from Congress? Former practices of giving half vote of one full vote, each for the chairman of the House and Senate Committees on Justice, is invalid. Any member of Congress, whether from the upper or lower house, is constitutionally empowered to represent the entire Congress. Why did the framers intended the JBC to be composed of 7 members only? The reason was for each co-equal branch of government to have one representative. There is no dichotomy between the Senate and House of Representatives when Congress interacts with other branches. The lone representative from Congress is entitled to one full vote. For the regular members, the regular members shall be appointed by the President with the consent of the Commission on Appointments. The term of the regular members is 4 years, but the term of those initially appointed shall be staggered in the following way so as to create continuity in the Council. 4 years for the IBP representative, 3 years for the law professor, 2 years for the retired justice, and only 1 year for the private sector. Now let us know the powers of JBC, or Judicial and Bar Council. The primary function of JBC is to recommend appointees to the judiciary, may exercise such other functions and duties as the Supreme Court may assign to it. Judges may not be appointed in any acting or temporary capacity, as this would undermine the independence of the judiciary. Let us know the supervisory authority of Supreme Court over Judicial and Bar Council. This authority of the Supreme Court over the JBC covers the overseeing of compliance with its rules. Supervisory power, when contrasted with control, is the power of mere oversight over an inferior body. It does not include any restraining authority over such body.
Requirements and procedures and divisions. Cases decided with the concurrence of a majority of the members who actually took part in the deliberations and voted. In no case without the concurrence of at least 3 of such members. When a required number is not obtained, the case shall be decided en banc. The Supreme Court en banc is not appellate court vis-a-vis its division. The only constraint is that any doctrine or principle of law laid down by the court, either rendered en banc or in division, may be overturned or reversed only by the court sitting en banc. There is but one Supreme Court of the Philippine Islands. It is the jurisdiction of this Supreme Court which cannot be diminished. It remains a unit notwithstanding it works in divisions. Although it may have 2 divisions, it is but a single court. Actions considered in any one of these divisions and decisions rendered therein are in effect by the same tribunal. The 2 divisions of this court are not to be considered as 2 separate and distinct courts, but as divisions of one in the same court. Now let us know its power and functions. The 1987 Constitution took away the power of Congress to repeal, alter, or supplement rules concerning pleading, practice, and procedure. The power to promulgate rules of pleading, practice, and procedure is no longer shared by the court with Congress, more so with the executive. Now let us know the limitations of the Supreme Court. Supreme Court shall provide a simplified and inexpensive procedure for speedy disposition of cases. It must be uniform for all courts in the same grade, and it shall not diminish, increase, or modify substantive rights. The following are the administrative powers of the Supreme Court. To assign temporarily judges of lower courts to other stations as public interest may require, shall not exceed 6 months without the consent of the judge concerned. Order a change of venue or place of trial to avoid a miscarriage of justice. Appoint all officials and employees of the judiciary in accordance with the civil service law. Supervision over all courts and the personnel thereof. Discipline judges of lower courts or order their dismissal. The period for deciding cases. For the Supreme Court, 24 months, 12 months unless reduced by the Supreme Court for the lower collegiate courts, and 3 months unless reduced by the Supreme Court for other lower courts. A period counted from date of submission. Case day submitted upon filing of the last pleading. Brief or memorandum required by the rules of the court. Original and appellate jurisdiction is the authority to hear and determine a case. The Supreme Court shall have original jurisdiction over cases affecting ambassadors, other public ministers, and consuls. Petition for certiorari, petition for prohibition, petition for mandamus, petition for quo warranto, petition for habeas corpus. Original jurisdiction also extends to writ of amparo, habeas data, and the environmental writ of kalikasan. Appellate jurisdiction. Supreme Court may review, revise, reverse, modify, or affirm final judgments and orders of lower courts in cases involving the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance or regulation, except in circumstances where the court believes that resolving the issue of constitutionality of a law or regulation at the first instance is of paramount importance and immediately affects the social, economic, and moral well-being of the people. Cases involving the legality of any tax, impost, assessment, or toll, or any penalty imposed in relation thereto, in cases in which the jurisdiction of any lower court is an issue. Criminal cases where the penalty imposed is reclusion perpetua or higher, in cases where only a question of law is involved. How cases are heard by the Supreme Court? In hearing cases, the Supreme Court may either sit en banc or in division of 3, 5, or 7 members. When it sits en banc, the majority of the members who took part in the deliberations of the case must concur or have the same vote in order to resolve the case. However, other cases or matters may be heard in division and be decided or resolved the same with the concurrence of a majority of the members, but in no case without the concurrence of at least 3 such members. Jurisdiction of Supreme Court en banc. Supreme Court en banc shall take notice of the following: all cases involving the constitutionality of a treaty, international or executive agreement, or law. All other cases which under the rules of court are required to be heard en banc. All cases involving the constitutionality, application or operation of presidential decrees, proclamations, orders, instructions, ordinances, and other regulations. Cases heard by a division when the required number is not obtained. Cases where the Supreme Court modifies or reverses a doctrine or principle of law laid down by the Supreme Court and bank or division. Principle of hierarchy of courts. A higher court will not entertain direct resort to it unless the redress cannot be obtained in the appropriate courts. The hierarchy is determinative of the venue of appeals and is likewise determinative of the proper forum for petitions for extraordinary rates. The rationale behind this policy arises from the following. First, to prevent inordinate demands upon the time and attention of the court, which is better devoted to those matters within its exclusive jurisdiction. Second, to avoid further clogging the court's docket. Process of rendering decisions. The Constitution requires that the conclusion of the Supreme Court in any case submitted to it for decision en banc or in division shall be reached in consultation before the case is assigned to a member for the writing of the opinion of the court. A certification to this effect, signed by the Chief Justice, shall be issued and a copy thereof attached to the record of the case inserted upon the parties. Whoever took no part or dissented or abstained from a decision or resolution must state the reason therefor. Same requirements shall be observed by all lower collegiate courts. The court must express clearly and distinctly the facts and the law on which the decision is based. Provisions under Section 14 applies to decision and not resolutions. Remember, resolutions are not decisions. Other important doctrines and principles. Principle of stare decisis. Principle of relative constitutionality. Lastly, operative fact doctrine. Principle of stare decisis. A ruling on a certain state of facts established in a final decision of the Supreme Court has to be followed in subsequent cases by all courts where the facts are substantially the same, regardless of whether the parties and property are the same. Supreme Court may be guided but is not controlled by precedent. Courts with new membership are not obliged to follow blindly a particular decision. Doctrine of relative constitutionality. The constitutionality of certain rules may depend upon the times and get affected by the changing of the seasons. Operative fact doctrine is a rule of equity. The law is recognized as unconstitutional law prior to its declaration of nullity, may be left undisturbed as a matter of equity and fair play. Prior to the declaration that a law is unconstitutional, it is considered as an operative fact.
So that's it. Thank you very much for tuning in. We, the Group 2, hope that you have learned so much about the executive and the judicial departments of the Philippines. Till next time!